Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I'm going to go through a quick recap of last night's filing, which was Justin Baldoni and Wayfarer's response to Blake Lively's motion to dismiss. The stream got a little bit derailed and ended up lasting 3 hours. So as promised, I'm going to go through this with you in 10 minutes or less because I have a meeting at 9:15. So, all right, let's see. Got my screen shared here. So we're just going to skim through some of the more interesting parts of it. All right. The First Amendment complaint contains hundreds of pages rife with factual detail about Lively's calculated efforts, first to extort and manipulate the Wayfarer parties into ceding total control over the film, and then to defame and scapegoat them when her plan backfired. Nonetheless, Lively refuses to accept responsibility for the trail of untold destruction she left in her wake. But she goes further still. Lively asked this court not only to dismiss the FAC, but also to award her attorney's fees and costs and treble and punitive damages for the Wayfarer party's constitutionally protected act of petitioning the court for redress of their grievances. In essence, Lively asked the court to find that she is immune from any culpability for her wrongful acts, and instead it is the Wayfarer parties who must be punished for daring to exercise their constitutional right to seek a remedy from the court for her lies. Hey guys, you sound tired, sweet friend. Well, I woke up about 7 minutes ago, so I'm going to sound tired for a while. I'm a different person in the morning. Okay, anyways, I got to kind of skim through, like I said. So, I don't have a lot of time this morning. The motion must be denied. The FAC specifically alleges abundant facts in support of the Wayfarer party's claims against Lively, based both on her own direct actions and on those of her co-conspirators and agents. The Wayfarer parties have pleaded allegations against Lively sufficient to defeat dismissal, and Lively's arguments often border on frivolous. In particular, Lively's argument that California Civil Code Section 47.1 immunizes her from liability would require the court to determine as a matter of law that she acted alone and without malice, and that she had a reasonable basis for her claims. In other words, to make findings of disputed fact not apparent on the face of the pleadings, which flies in the face of the well-established rules governing motions brought under Rule 12b-6. When the court assumes the truth of the facts set forth in the FAC, as it must in ruling on this motion, the only possible result is a denial of the motion in full. Okay. Regardless, any technical defects or instances of inartful pleading in the FAC can be readily cured by amendment, which is freely allowed, and the Wayfarer parties are every day obtaining further facts to plead in support of each of their claims against Lively. Yes, please share the further facts. Furthermore, and they're not going to do that in this document, but if they do a Second Amendment complaint, yeah. Furthermore, the Wayfarer parties can amend their complaint to more fully incorporate the allegations of Exhibit A into the body of the complaint, mooting the motion to strike. Finally, even in the extremely unlikely event that the court determines that dismissal without leave to amend is appropriate, Lively is still not entitled to the award of fees, costs, treble damages, and punitive damages that she seeks. The draconian, one-sided sanctions that Lively demands under California Civil Code 47.1b are, in a matter of first impression, barred by the Noor-Pennington Doctrine, which precludes the imposition of liability for the exercise of rights protected by the petition clause of the First Amendment. The First Amendment protects the right to petition the government for redress of grievances. In other words, the Constitution safeguards Americans' right to ask the government to take action, such as by bringing legal claims. The Noor-Pennington Doctrine bars courts from punishing litigants for bringing good faith claims, including through the imposition of harsh penalties like the treble damages award Lively seeks here. Because the Wayfarer parties have brought good faith claims against Lively that are neither objectively baseless nor subjectively brought for improper purposes, the First Amendment protects them from being punished for the act of seeking relief from this court. In short, the motion must be denied, or at most granted with leave to amend. In no event on this motion or at any stage of this proceeding will the First Amendment permit the extreme or unconstitutional award of fees, costs, and treble and punitive damages that Lively demands. All right. Oh, thanks, Winks, for the reminder. Are we expecting another drop today? Well, she has to respond to Jed Wallace's Texas lawsuit by the end of today, so yeah, that's what I'll be looking for. Okay. So we went through the legal standard and factual background last night with my friend Omar, the Tilted Lawyer. He's a lawyer out in California. If you haven't subscribed to his channel yet, go check it out. So I'm not going to do too much of reading this morning. Let's see. The FAC states a claim for defamation against Lively. Okay. And I'm going to post a link to this document, and I'll pin it in the comments section of this video once I'm done with the live stream, so you guys can read all this yourself if you want to. Last night, and if you want to watch that for entertainment purposes, last night when we went through this whole document, I was also joined by Bruce from Oregon, as well as Be Better, who's on TikTok, and we had a good time talking. So, all right, let's see. Lively is liable for statements made by the Sloan parties and Reynolds under the principles of agency and the doctrine of respondeat superior. Okay. As the Sloan party's employer, Lively is also liable for their statements under the doctrine of respondeat superior. Under the doctrine, an employer may be held liable for a defamatory statement made by its employees. Okay. So they're saying that the Sloan parties communicated with the press on Lively's behalf. They acted with authority that the principal, Lively, intentionally conferred upon the agent, Sloan, or intentionally or by want of ordinary care, allowed Sloan to believe herself to possess. Okay. As to Baldoni, the FAC alleges that the Sloan parties made statements to third parties, including without limitation to the New York Times and other news outlets, to the effect that Baldoni is a sexual predator who sexually assaulted Lively, and that Baldoni retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. The Sloan parties also made other false statements in response to media inquiries concerning Lively's wrongful accumulation of power over the production, the means by which she did so, i.e. false accusations of sexual misconduct, and the resulting turmoil. Although not in an employment relationship, Reynolds, too, was acting as Lively's agent when he defamed the Wayfarer parties. As alleged on at least 2 occasions, he stated to execs at WME that Baldoni and Wayfarer's, talent agency, that Baldoni is a sexual predator. We read through a lot of that. Okay. Well, actually, we read through everything, but it took us a while. Okay. Although the Wayfarer parties submit that Lively personally approved or authorized the defamatory statements made by the Sloan party and Reynolds, Lively is liable regardless because she ratified them after the fact. In California, ratification is a well-established doctrine for assigning vicarious liability to a principal for torts, even where those torts are outside the scope of the agency relationship. Okay. Here, the Wayfarer parties have alleged that Lively fabricated her claims of sexual misconduct and knew or had reason to know that there was no untraceable smear campaign. Assuming the truth of these allegations, as the court must for the purposes of this motion. Okay, let's see. For purposes of a 12b6 motion, sorry. It follows that Lively knew the statements of the Sloan parties and Reynolds, which stated the opposite, contained falsehoods. Okay. It's reasonable to infer Sloan and Reynolds were speaking on her behalf or with her authorization. Right. B, Lively made defamatory statements herself. Okay, so they're talking about how she did it in her individual capacity, not just through Reynolds and not just through her publicists, Sloan and Vision PR. Okay. Lively told the New York Times that the Wayfarer parties engaged in, permitted, and or failed to prevent sexual misconduct and orchestrated a smear campaign in retaliation for Lively's purportedly protected disclosure thereof. Okay. Defamatory statements are not privileged. Litigation privilege does not apply. Like I said, I'm going to post this document in the comments for you guys. The sexual harassment privilege does not apply. Section 47.1, or what Lively calls the sexual harassment privilege, protects communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination. Lively's defamatory statements were made with malice and without a reasonable basis in fact. Okay. Those requirements that the communications be made without malice are why Lively's arguments fall flat. As alleged, Lively fabricated her allegations of sexual harassment either wholesale or by exaggerating benign and not harassing interactions in a concerted, malicious effort to seize control of the film and later to restore her reputation after a well-publicized series of marketing missteps that sullied her reputation. All right. This is all kind of outlining stuff that we've seen before. So, like I said, I'm going to post this document for you guys in the comments. It might take me a minute because I have to do something for work first, but look out for that. Let's see. Yep, that's my cue. And make sure I didn't miss anything that I wanted to go over this morning. Like I said, we went over the whole document last night, but it's a much longer stream, so. All right. Lively is liable for her direct actions as well as by conspiracy. All right. Okay, that's all the time I got for you guys this morning. Like I said, I'll post a link to the documents as well as a link to the full reading of this document from last night in the comments. So just give me a minute to do that. And thanks, everybody. I will see you all soon. I'm expecting at least one stream tonight. We'll see if anything else comes out today. All right, bye, everyone.